Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3032. United States of America versus James Fitzgerald Honesty Appellant. Mr. Katzoff for the appellant, Mr. Goodhand for the appellate.
May it please the court. Good morning. My name's Howard Katzoff, attorney for James Honesty, appellant in this case. It's a criminal case involving Mr. Honesty's plea agreement, written plea agreement to plead to 2 counts of an indictment, felon in possession of a firearm and possession with intent to distribute PCP. The plea agreement included certain promises both ways, but significantly included the government's promise to allocute to cap its allocution at the top of the applicable guideline range as determined by the court. Mr. Honesty contends that the totality of the government's allocution supported a position that the next highest guideline range was perhaps more appropriate. At a minimum, that the applicable guideline range did not seem to be appropriate, and is claimed that based on the breach of the plea agreement by the government, that he should have his sentence vacated and be remanded for resentencing. And we would submit the court should apply the 3-factor test. We think the case should probably be reassigned to a different judge.
Do you have any support for reassignment, a case in which we have reassigned in a situation like this, a sentencing?
I think King Gore was a reassignment, a case where the factors aligned for reassignment. I believe the Wolf case was one where the factors were discussed, and in that case, reassignment was not. I would say in this case, what we have is a plea and sentencing. So the matter is relatively much less in terms of a record than a trial matter. And therefore, the use of resources or the potential waste of resources is minimal. We always say you can't unring the bell. I would submit that for the judge and the judge's determinations, and considering the issues that we believe were improperly raised, that should swing in favor of a reassignment and the appearance of and fairness of justice. So in looking at the 3 factors, because it's a plea and sentencing, because you can't unring the bell, I would submit that the King Gore should apply.
And what's your best support for your assertion that the government's sentencing memorandum, the statement that the guidelines did not accurately capture the prior criminal history, that to the extent that we were only to recognize that as clear error, what's your best support for the notion that that was prejudicial to Mr. Honesty if we rejected all your other assertions of error?
Which particular? Because
in the sentencing memorandum.
Well, the sentencing memorandum starts with the problem is it starts with inviting the judge to consider variance.
That's what I'm referring to. And so assuming we thought that was error, that it did invite a variance, if that were error, what's your best basis for saying, well, that's prejudice here? Because there's a lot of other, if we were to only hold that that was error, there's a lot else that the district judge refers to in support of the variance that he apply?
Well, it's sort of the timing is the way I look at it. The government submitted its memorandum and invited the court to consider variance by the language of the written advocacy. But at the same time, within the written memorandum, and then repeated and again emphasized in the oral advocacy, were the indications specifically that the criminal history did not accurately capture the criminal history of Mr. Honesty, which specifically invites consideration of the higher guideline range.
You opened your answer by saying something about timing, but I'm not sure that I caught what your point on timing was.
So we start with the written advocacy, and that is before the judge issues an order saying it's going to consider basically all the things that were mentioned in the government's written advocacy memorandum. So the written memorandums first. The judge then says, now I'm considering an upward variance or departure, and lists literally the factors that the defense, that the government raised. And so it's almost impossible to determine that the judge wasn't influenced by that. And under the standard of being able to show a reasonable likelihood that it affected the sentence, because the government's memorandum raised those issues, the underrepresentation of the criminal history. It had inflammatory information about crime rates, gun violence, things that apply to everyone that wouldn't necessarily support a variance. Specifically provided information which the judge then took to determine that a career offender, that he was a de facto career offender when technically he was not. None of the offenses that the judge referred to would have made him a career offender. And so these are all run-of-the-mill drug and gun kinds of factors that are properly considered. But the government's memo started it, and then it became exaggerated and emphasized more significantly in the oral advocacy when the AUSA again repeated that the 92 to 115 range appeared to be appropriate, that the current criminal history points don't really capture the totality of the criminal history. The government discussed and provided information about a victim impact statement from 12 years ago, not the current case, but 12 years ago, which was inflammatory, seemed to be marginally relevant. Certainly when you figure that the government's responsibility, that those kinds of discussions went far beyond what was permitted under the plea agreement.
So the government argues that all of that information is relevant to support the government's allocution for a sentence at the top of the guideline range, the agreed guideline range, the corrected agreed guideline range. And then, the plea agreement has this specific proviso that reserves the parties' rights to answer inquiries from the court, including if the court is contemplating a sentence outside the guideline range. And the district court here obviously did request argument on that. How, in your view, should the government have responded differently from how it did respond in exercising its prerogative to answer those inquiries?
Well, I would say that should have answered it more in line with some of the cases where, and I don't remember the specific names, but they're in the brief, where prosecutors held firm and said, this is our agreement, and
They literally said that.
Excuse me?
They literally said that.
They did, but but
multiple times.
bookended with, well, actually, one time he said, I don't think. It didn't even say unequivocally, I can't do this. It said, I don't think I can do this. But when, the whole concept of giving lip service to the plea agreement while at the same time providing information that suggests a different guideline range, those weren't factual summaries that were given. Those were conclusory statements suggesting in violation of the agreement.
It sounded like all of the facts that were given were arguments in favor of the high end of the guidelines range. So back to Judge Pillar's question, what was not an argument for merely the high end of the guidelines? Maybe that wasn't Judge Pillar's question, but that is my follow-up to Judge Pillar's question.
I think that, first of all, most of the statements, the inflammatory statements and whatnot and the statements about the higher criminal history category were not in response to the court's questions. I guess you could say they were in general in response to the court's notice that it was considering an upward departure or variance. But generally, in many of the cases,
I want to give you the opportunity. What is an exact quote from the transcript that could not be understood to be merely an argument in favor of the high end of the guidelines range?
Current epidemic of gun violence in the community, combination of firearms.
So just stop with that sentence. Why is that not an argument for the high end of the guidelines range?
Because that is something that applies to all defendants. It doesn't differentiate where this defendant should be in the guidelines or outside the guidelines. That is just general inflammatory information.
It applies to all defendants. It seems like it's speaking within the guidelines.
It has the appearance of being inflammatory under the circumstances when you have a dual responsibility to provide information as requested by the court, but honor an agreement to
defense counsel was arguing for a lower sentence than the high end of the guidelines range, right?
That's correct.
So the government, in order to defend its position for a sentence at the high end of the guidelines range, had to state some facts to suggest that this defendant's conduct and the context of the crime were worse than a sentence that would be worse than the conduct that would call for a sentence at the low end of the guidelines range. Right?
No doubt that the prosecutor would be allowed to provide certain information.
By saying there's a drug epidemic and this is a particular neighborhood, why would that not be an argument for the high end of the guidelines?
Well, I think if you isolate each statement, then you could try to justify it. But I think that these cases say you have to look at the totality of the advocacy and the totality of the advocacy, notwithstanding the occasional statement that, we made an agreement to cap our allocution. Many of the statements suggested that a higher guideline range was appropriate. That goes beyond the pale of suggesting that a sentence at the top of the range is what's appropriate. All of those comments that suggest a higher range is appropriate signals to the court that I'm not satisfied with this range, and even a sentence at the top isn't sufficient. It really should be above that. Those are improper statements and comments when the government agrees to cap its allocution.
If this were to be vacated and remanded and the government were to once again argue in favor of the high end of the guideline range, what can they not say that they said before?
I think they cannot say at the same time they're saying we're asking for 96 months. They cannot in the same sentence or breath or next sentence say, and we calculated and believe that the 92 to 115 month is really the appropriate one. That's the reasonable one. We thought it at the time, and we still believe that better captures it.
And your client agreed to that. mistakenly, apparently, but
Well, mistakenly, but the government shouldn't be able to make a mistake in the plea agreement, have a defense counsel not catch it, and then use it as a basis to say this is the more reasonable sentence. The applicable guidelines, the applicable guideline. Their agreement was we're bound by the applicable guidelines, and to spend time talking about sentence ranges other than the applicable guideline violates the spirit and letter of the plea agreement.
you argue in your opening brief that the guideline range already accounted for Mr. Honesty's possession of multiple drugs, including PCP, which the court identified as especially dangerous. And you point to the enhancement that Mr. Honesty received under 2K2.1B6. But the government points out that enhancement is for committing a felony offense while armed. And the government asserts that doesn't capture the concerns that the district court articulated about the multiple drugs, including PCP. You don't respond to that in your reply. Do you have anything you would add about the extent to which that guideline encompasses already the dangerousness that the district court identified?
I'm reasonably certain that enhancement was because it involved another offense. In this case, it was a drug offense, a gun and drug, and a 4-level enhancement. Additionally, if you look at the guideline calculation in the pre-sentence report, it shows that there are grouping rules and that all of the drugs were considered, they were applied, were given an offense level, and the total offense level and criminal history scores were category were scored. And so in the course of that, they were all accounted for in the normal sentencing. I guess I didn't think that was a significant issue because it seems in the pre-sentence report, everything is counted. And therefore, I didn't view that as a significant issue.
On remand, if this were to be remanded to the government, imagine the government says the following: we recommend 96 months. The defendant agreed in the plea agreement to a guidelines range up to 115 months. That shows that 96 months is not too high. Is that okay?
I believe it's not okay.
I think that's an argument in favor of 96 months. It's a way to show that 96 months is not too high.
I believe that the fact that it's in the plea agreement, one, mistakenly prepared by the government, not called by the defense, but secondly, the fact that the range is reasonable for appellate purposes, not for sentencing argument at the district court level when the agreement is to cap the allocution at the top of the applicable guideline range. So to use that as a basis to get around the agreement would be improper, would be my position.
I appreciate that.
Thank you.
Good morning, Your Honors. David Goodham for the United States. I'd like to address some of my opponent's arguments and certainly address any of the court's questions. But before I begin, I'd like to start with sort of a global point, if you will. In arguing for the top of the guideline range sentence below, the government submitted a 21-page sentencing memo and argued at the hearing for 6 transfix pages. So for 27 total pages, advocacy for the government. In those 27 pages, the government asked for a top of the guideline sentence of 96 months 7 times. That's once every 4 pages. Now, I understand that an implicit breach inquiry does not involve a simple math equation. My point in emphasizing the repeated refrain of the government for top of the guideline sentence is this: there's a reason neither the defense counsel nor the trial court below said a peep about the possibility of an implicit breach here. And the reason is there was a consistent adherence to the plea agreement's promise on the part of the government. I will add that Pollard emphasizes that when you're talking about implicit breach, you're talking about nuance. You can't just point, I'm sorry, Your Honor. When you're talking about implicit breach, you're talking about nuance. You're not talking about an express provision of the agreement that is violated. My opponent agrees we are in the category of implicit breach. And what Pollard says is when you're talking about such nuances, we're going to put a significant amount of weight on the contemporaneous reactions of the defense counsel and the trial court. Here, we have a vacuum with respect to their reactions to the government's arguments.
So the defense counsel seems to have dropped the ball at the sentencing allocution, but it jumps out, and this is at page, I guess, 19 of your sentencing memorandum or your colleague's sentencing memorandum at A135. In the memorandum, defendant honesty's 8 criminal history points do not capture totality of his criminal behavior. To me, that is an invitation. The guidelines range as calculated and represented in this memorandum and doesn't capture what this person did. That seems like, I mean, implicit, yes, because it doesn't say therefore vary, but that is really effectively saying guideline range doesn't capture, go higher. And the district judge responds promptly by tracking that sentiment and asking for further submissions. That seems like pretty strong evidence of implicit breach.
I disagree with Your Honor's reading of the record with respect to the government sentencing memo, and I want to make a couple points in response. Excuse me. First, what Pollard counsels, and I think this is critical to this court's analysis, and this is at page 1025 of the Pollard decision. Pollard says, it's true the government pressed its case against Pollard at sentencing with considerable force. And in particular, Hap Weinberger, Secretary of Defense statement made references to treason. But what Pollard said is that statement was just as consistent with a request for a long prison sentence that would be short of a life term as it was consistent with a lengthy term. And that's what's going on here.
I can see that with respect to all of the sort of qualitative characterizations of the conduct of the defendant. He did this, he did that. It's really the sort of technical, to my ear, door opening character of this. The criminal history points do not capture the criminal behavior.
Sure.
Which is a way of saying, and that is tracking what the guidelines identify as a ground for going up above the guidelines. So it's basically saying, here's a ground that this judge knows is a ground for upward variance, which is why he reads this, turns around, asks for briefing on that. And yes, at the hearing, government counsel acknowledges the obligation to stay within the guideline range, but has a statement that, I mean, if I have to stick with this, but, and then it's like in contrast to that obligation, I'm going to tell you why this case why this person is so dangerous. I mean, if surely it can't be in compliance with a plea agreement commitment on the government's part to not ask for anything above the top of the correct guidelines range. It can't be consistent with that for the government to say, well, we're bound to advocate within the guideline range, but this is a really serious case, but the range doesn't take account of this. We're sticking with the guideline range, of course, Your Honor, but this case is far different from any of the guideline range cases we've seen before. I mean, at some point, the drumbeat of, we're asking for the top, we're asking for the top, or it doesn't correct for that.
If I may respond to a couple, first I want to talk about the sentencing memo, and I want to put your Honor's focus on that language in the sentencing memo in context.
Okay.
And then I will transition to the sentencing hearing, because I think context is very important here. And as my opponent rightly points out, we're talking about totality of circumstances approach to this. You have to look at this mosaic. You have to look at the constellation of facts. Let's start with the sentencing memorandum. First, the government's phraseology, I think, is critical here. The government at JA 135 says the criminal history does not capture the totality of his criminal behavior. No citation to a departure provision, no reference to a variance there. And that, I would suggest, should be contrasted with the actual departure language, which is 4A 1.3A1, which says substantially underrepresents the seriousness of defendant's criminal history. So a small point, but I think it's relevant in the mosaic. The government understood that this was a permissible argument for a top of the guideline sentence. And again, let's put this in context. The defendant was arguing for a bottom end of the guidelines range. So that's my first point with respect to the memorandum. Number one, and number two, Judge McFadden is obviously an experienced judge. He understands the guidelines. He understands his authority within the scope of the guidelines. So I think in the context of plain error, to assume that this was a triggering factor for the judge is probably not appropriate, given that the defendant has to show a plain, clear, or obvious breach.
What about in the end of that very same paragraph in the sentencing memorandum? Starts defendant honesty's 8 criminal history points, does not capture totality of his criminal behavior. It ends incorporating those points into defendant's honesty's criminal history score would result a guideline range of 92 to 115 months, which was the guideline range contemplated in the plea agreement.
Sure.
It doesn't say erroneously contemplated or contemplated the plea agreement, which to be sure was, contained error and has since been corrected, and which we're not basing our argument on. I mean, this is really hard to square.
Again,
And you're doing a good job. I mean, I do think that your point about substantially underrepresents versus does not capture,
a further point. Again, context is important here. It's actually the government that gets the parties to the correct criminal history point score.
I noticed that. Yeah.
And the context here for the government statement that you've quoted comes on the back end of roughly 5 or 6 pages of the government laboriously and scrupulously going through the criminal history points and getting the parties and the PSR writer to the correct score, which was 8 points, as opposed to when it started at 10 points, I think, or 11 points. So when the government makes that declaration that Your Honor has quoted, it's in the context of the laborious sort of detail-oriented nature of, hey, this was a complicated criminal history score, and the parties screwed up actually at the beginning. We're now on the back end, and I think from the government's perspective, it's fair for the government to point out is, well, on the one hand, he does get the benefit of the lower criminal history score that we've now produced for you and that everybody agrees ultimately is correct. But also, on the other hand, we think there are reasons why that criminal history score doesn't accurately capture the way that the totality of his criminal behavior. If I can move to the sentencing hearing, I'm sorry, go ahead, Your Honor.
I just think if you're really sticking to the obligation to stay within the guidelines, you would not say this range doesn't accurately capture. You would say, and within that range, which is corrected, he really belongs at the top. This is not your average offender of this type with this history. This is somebody who is at the most serious end of that. I mean, that is not the way this was presented in writing or at the hearing. So go ahead and
Well, I do want to actually close the loop on the sentencing memo. The quotation that Your Honor has focused on is that, excuse me, JA 135, excuse me. Well, on the next page, 136, for that reason, and given the above factors, the government believes that 96 months at the top of the range is necessary and mandated. And then on page 137, defendant honesty should be sentenced to a term of prison of 96 months followed by 3 years of supervised
Of
release.
course, no, I mean, again and again, the government formally asked for that. That's why I'm saying this is an implicit, it's a claim of implicit recommendation, urging to be outside the range.
Sure.
You can say, as many times as you want, and the district judge understands that you're not going to ask for a different number. I mean, that would be an explicit breach, right? But to sort of have all this laying out of the erroneous, much higher, and then you understand my point. I see you. I appreciate that the request is in fact within the range. And so
Okay.
you were
I won't belabor that. But I do think, again, when we're in the context of plain error and we're talking about the contemporaneous reactions of both the trial court and the district court, we should assign, as this court has said in Pollard, great weight to the fact that this was not something that caused defense counsel to blanch. I'll leave it at that. I want to talk about the sentencing transcript. Before I do want to remind the court, though, that also, again, when we're talking about a totality of circumstances approach here, we can zero in on particular phrases, we can zero on particular sentences. But when you're talking about the mosaic, you have to ask the question, did the government adhere to its promises? And we think that totality here demonstrates that. But let's focus on the sentencing hearing transcript. Obviously, we have a different reading of the transcript that's just been posited by Your Honor. Our reading of the transcript is this. At JA 155, the court, quote, invited argument on its minute order, which made reference to the possibility of a variance or not. And I think the critical part of the government's response to that invited argument is at JA 160. What the government does there is assiduously stamp down the notion that it can argue about this. So at JA 160, the first thing the AUSA does is remind the court, quote, we did cap our allocution at the top of the applicable range. Then the AUSA goes on and declares, I can't stand here and advocate for an upward departure or an upward variance. So boom, right off the bat, following the district court's invite argument, what we have here is the AUSA saying, look, I can't argue this. I capped my allocution. We have promises to keep. Then, critically, what I think the transcript betrays is the government then simply repeats its sentencing memorandum argument. Now, if this court disagrees with my take on the sentencing memorandum argument, which is that's a perfectly permissible argument to make both for a top of the guidelines range and perhaps a variance, if it's doing double duty, then it's permissible. And what the AUSA does at JA 160, 161 is the AUSA actually quotes from its sentencing memorandum. And this is a quote. We did mention this in our sentencing memo, where we stated that Mr. James Honesty's criminal history points do not really capture the totality of his criminal history behavior. The government is simply repeating what from the government's perspective is already a permissible argument in support.
Right. And if you don't think it's a permissible argument, then, I think it's really the opening the door in the memorandum, because once then the district judge responds, this is Mr. Honesty's argument. Once the district judge responds to the sentencing memorandum saying the criminal history points don't accurately reflect this offender's criminal history, then the judge asked for the parties to address the upward variance on this basis, and they do. And then once the district judge is asking, it's harder to see that as clear error, right? The district judge is saying, why shouldn't I vary? Why shouldn't I vary? And the prosecutor is saying, well, he is a pretty serious offender. He does have a lot. And I wonder about that. It doesn't seem like there was an objection, and there isn't an objection on appeal to the whole narration of the error in the original plea, it just feels like once you put that in front of the court, I mean, that's what he then gravitates back to.
Well, again, when we're talking about feeling and perception, again, I think that perception was not one taken away by defense counsel, nor was it one taken away by the district court. The district court, of course, understood the plea agreement. The AUSA reminded the district court of the plea agreement requirements. The district court has a duty just as much as defense counsel to raise a possibility of a breach if the district court perceived it. Again, complete silence. I just want to finish my sentencing hearing point, which is we have the AUSA closing that loop. On the one hand, the court has said, invited argument. The AUSA says, I'm not arguing. I can't argue. Reminds the court about the allocution cap. Simply repeats a prior permissible argument from the sentencing memo, and then critically returns to this is at JA 161. Again, the AUSA says, I can't advocate for a variance or departure under the plea agreement, JA 161. And the entire response that the AUSA offers is a request for a 96-month top of the guidelines range at 161. Honestly, if I might, we haven't really talked much about, these are all fact-bound cases, and there's a lot of variation within cases. I think a good barometer or a good template for comparison here is the Thomas case from this court. In Thomas, the defendant pled guilty to interstate communication with intent to extort. The parties agreed not to seek a different U.S. guideline calculation and thus agreed not to include an enhancement for defendant's demonstrated ability to carry out his threats. At the sentencing hearing, however, the district court brought it up, the enhancement, on its own initiative and asked the prosecutor about the application of this demonstrated ability to carry out threats enhancement. And the prosecutor, again, with some sort of, when you're speaking extemporaneously, you're not going to be choosing your words particularly carefully. But the prosecutor said, well, look, he was in a, quote, unfortunate and somewhat difficult position, and stated it was our interpretation and understanding of the facts that the offense did not involve the defendant's ability to carry out this threat. That's at 999 F3rd at 728. When the judge pushed back and asked whether the actual demonstrated ability to carry out the threat was irrelevant as a legal matter, the prosecutor responded with sort of very heavily laden double negative. The prosecutor said, we are not arguing that legally that it doesn't apply. We are not asking that it apply in this case. And that's at 729. The defendant argued the prosecutor had essentially effectively agreed the court should apply the enhancement. This court rejected it. Said not only not plain error, but no error at all. And the court said, even if we understood the double negative as a feeble admission the enhancement might apply, we would still hold the prosecutor did not breach the agreement. That's at page 729. The government did not at any point seek the enhancement. The district court raised it without prompting, and the district court applied it over the government's objection. I would suggest all of those facts apply here, and that Thomas is a very good template for this court's analysis.
By chance, do you know what the pretrial sentence report recommended?
I do. At the top of the guidelines range, 96 months. And so consistent with the government's refrain for a top of the guidelines sentence. Again, I want to make sure I answer any of the court's questions, and I will address anything but I do think there are two critical features of this case. One, this is plain error. We don't think there's a breach here. We think the mosaic, the constellation of facts demonstrates the government adhered to its bargain. And there's a reason there's silence from defense counsel. Number two, it certainly can't be said that this was plain, clear, or obvious error. we are at most talking about phrases/sentences that might have hidden meaning. And when we're in the context of debating the nuance of a phrase or a sentence, when a prosecutor is doing his or her best to answer a court's question on the one hand and adhere to promises on the other hand, when we're in the context of having a reasonable debate about that, then I think we're outside the context of plain, clear, or obvious error. From the government's perspective, the government did not implicitly breach the plea agreement here. It stuck to the letter of the agreement. There was a consistent refrain. It had a job to do with respect to a top of the guidelines argument.
Can you talk a little bit about prejudice? If the court were to find that the government breached, we would still have to find prejudice, right?
Yes, and that's of course different. If we're in preserved context, then all bets are off. You automatically get a remand. But when you're in plain error context, it's the defendant's burden to show not only just a substantial prejudice attendant the error, number one, but then a fundamental miscarriage in prong 4 of Bolano. And here, there were many facts, with the court's permission, there are many facts in addition to the criminal history of the defendant that the court relied on.
Would it include brandishing the weapon and not merely possessing it? Would it include abandoning the gun feet from an elementary school? Would it include that he possessed 3 different dangerous drugs, in particular PCP, which poses an extreme danger to the residents of DC?
Yes, absolutely. And that's the transcript page. This is a 13-page explanation from the court. And the first 4 pages focus solely on what the court calls the, quote, incredibly serious offense. Many of the facts that Your Honor just recited support that.
Did the pretrial sentence report identify those considerations?
I believe that's accurate, Your Honor. There's no doubt that the court focused on the defendant's, what the court called the long and disturbing criminal record. That's at page 36 of the transcript. But I think most saliently, what the court focused on, even in the context of the criminal history, was the similarity between the defendant's consistent convictions. And so at page 36, the court says, I have 5 convictions for having loaded weapons, 3 convictions for possession with intent to distribute. And I'm struck not only by the number of offenses, but the severity, and that most of them involve weapons. And that's at page 37. But then I think another feature of the court's sentencing that has nothing to do with criminal history is the sort of brazen inability of the defendant to exercise restraint, if you will, when on supervised release. And this is sort of critical, the portion of the court sentencing. It's page 37 of the transcript. The court sort of aghast says less than 10 months after being released on his CPWL, he engages in a carjacking. 9 months after his carjacking release, he has the Maryland armed trafficking case. And 6 months after that, he's arrested in the present DC case. And as the court says, that's quite a crime spree for someone who's been in and out of prison for a long time. And that's at page 37 of the transcript. So, if we're talking about the sort of minutia that the government made with respect to the criminal history points, not adequately demonstrate the defendant's criminal history, I think what we have here is a district court judge who went way beyond just focusing on that feature of the case.
I think there's more. The district judge talked about. I take issue with the tone of parts of your memorandum, which seems to variously blame your mother, your father, the Bureau of Prisons, and the probation office. The district court also talked about the defendant's behavior during the sentencing hearing itself. And I think sometimes the defendant was interrupting the district court and not, I also, your demeanor throughout this case has not at all been consistent with remorse. You actually had to be removed at the last hearing because of your outburst.
There's a lot there.
This would all go to prejudice, right? Even if we were to find some kind.
Yes, absolutely. Again, it's the defendant's burden when we're in that context. He hasn't disagreed. We're in plain error land.
Do you think that the district court adequately explained why the sentence wasn't higher?
Why it wasn't beyond the 115?
Yeah.
I think the court had a very reasonable and rational explanation for why it was comfortable with 115. And I think, again, the court focused on the similarity between the incident offenses and the defendant's past convictions, number one. The court also focused on the fact the defendant had committed many of the offenses soon after being released. And then the court...
All those speak to why it should be at least 115.
I believe so.
I'm not sure I see much of an explanation for why it shouldn't be higher than 115.
Well, I mean, I think from Judge McFadden's perspective, he was varying upward. The explanation had to be, okay, I'm outside the guideline range of 72 to 96 months. I'm going up. I need an explanation for that. And I think that the record amply...
It's rare, but sometimes the U.S. Attorney's Office will appeal a sentence as too low, correct?
It does happen for sure, but it's certainly a rarity in my experience. But I think the bottom line here is there's no debate really from the government's perspective that there was an adequate explanation here. I've run well over my time. I would ask that the court affirm the judgment and conviction below. Thank you.
Thank you very much. And does Mr. Katzoff have rebuttal?
2 minutes.
All right. We asked you many questions and took you over your original time, but we'll.
I will try to keep it short. Just,
I have a question. Where did you seek resentencing before a different district court judge?
I did not specifically reference that in the briefs. All that was in the briefs was that we felt that a remand and
It's not
resentencing.
argued. Is that correct?
That's correct.
Thank you.
I wanted to just, with reference to government counsel's focus on the reaction of judge and defense counsel. And the emphasis on putting things in context. First of all, I think the record's clear, but defense counsel, I think, was a substitute counsel for a case that had been going for a long time, for I want to say 2 months, asked for about 60 or 90 days and barely got 50, I think, because he had a murder trial in PG County in the interim when he entered his appearance at the end of July. And so to try to put a lot of weight on defense counsel's, one, catching the error, two, reaction, it's
So you don't make any ineffective assistance
I
argument.
didn't think it rose to the level, and so there is no ineffective assistance argument with regard to that. But in context, there's a reason that the cases say that that these issues are to be reviewed at the time of the appeal, not at the time of the reaction of the judge or not the reaction of the judge. In this case, as I argued earlier, this started with the government's sentencing memorandum, then the judge's minute order, then the judge adopting most of the government's arguments.
I'm not sure I entirely followed what you just said about these issues are to be reviewed as of the vantage of the appeal, not at the time. I mean, we're on plain error review because there is an obligation to raise the objection at the time.
That's correct. And so it puts it into the plain error category, but it's a little bit strong to make a decision at the appellate level based on whether the district court reacted or didn't react. And in this case, the district court came on board with the government's recommendation and followed suit right along the lines the government had laid out. So it really doesn't say much in the context that the judge didn't react at the time. And that's a reason to somehow find it doesn't meet plain error standard.
Do you know if and I'm not sure, Should we presume in a typical appeal that the defendant's attorney read the government's sentencing memorandum?
I would think in the normal course, I don't know if there's a basis to
It may be a
presume that or not.
Maybe a rebuttable presumption, but
I have to say I've never been asked that question, and I don't know the answer.
I bet you also never not read a government sentencing memorandum before you.
Absolutely. So it's a little alien to me to consider, and I'm not sure whether the law
I'm
has
not sure,
addressed the
maybe we
presumption.
shouldn't, but it's possible that that should be sort of a rebuttable presumption about a defendant's counsel. And also maybe that there should be a sort of, I don't know if it's technically a presumption of regularity, but a sort of rebuttable presumption that the government is being faithful to its promises in a plea agreement, absent sort of sufficient evidence to rebut that presumption.
Well, it seems that the language implicitly went very far in this case, and so
Evidence to rebut.
so
Even if there were presumption, you think there's enough evidence here to rebut it. I get that.
yes. The Thomas comparison, I would just submit, very distinguishable. Those issues weren't first raised by defense. They were raised by a very tough district judge. The prosecutor was pushed and held pretty
fair district judge.
Yes, fair. I don't mean that word to be, but one who wants to get to the point, and that prosecutor held firm, far firmer than what was gratuitously, without being pushed, provided in this case. So my point is, I think it's very distinguishable. On plain error, it seems from the language that the implicit breach is clear. It seems that it affects substantial rights under the King-Gorst standard of having to show a reasonable likelihood that it affected the sentence, even with all the other factors, some of which we've alleged were improperly considered by the judge, and I'll rely on the brief for those arguments that Mr. Honesty makes that standard. And obviously, if he makes those prongs, then it affects the fairness, integrity, and public reputation when a sentence is affected by a breach by the government and request for a higher sentence. So we would ask for it. I would ask the court to do the three-factor analysis, even though I didn't specifically address, and I only asked for remand and resentencing.
So are you today asking for reassignment?
I am.
So, Mr. Kassoff, you were
What
appointed.
basis,
Oh, I'm
just
sorry.
so I can understand the basis.
Well,
You clearly didn't raise it, so the government hasn't had a chance to respond.
that's correct, except the government's only had an opportunity today. My position is it's relatively straightforward, the three factors. And
Normally, we would have to find the judge did something wrong.
well, not necessarily. We just have to find that it would be hard for the judge to not be affected by the decisions that were made.
I asked you for your best case. I've been on this court long enough to know how rare that is.
Well, that is true, and it is not often, but I would say that it's impossible to unring the bell, as we say a lot of times with juries. And in this case, I would say with the judge who's been through the sentencing process and has been affected by the breach, that it would apply. Well, we don't know, but I would submit that it's sufficiently an issue that it would be the appropriate
I mean, if we don't know,
remedy.
doesn't that mean that you lose under the plain error review?
I don't think that we necessarily lose if we're at a point of determining the remedy and whether a reassignment is part of it.
But if we don't know whether the alleged breach prejudiced the defendant, it seems like you haven't met the plain error standard.
Well, our position is that it has affected him. It has affected the sentencing, has affected the judge. Just, I'm saying that we can't be in the minds of the judge. So these are conclusions that are drawn based on the facts that are presented on the record. And I'm not trying in answer to Judge Rogers' questions to say that I know Judge McFadden is not fair or couldn't be fair. I'm saying that it's inappropriate to put Judge McFadden in that position. We don't blame the judge.
So you're clear, is the judge had a pre-sentence report before him.
Correct.
That spelled out the criminal history.
Correct.
The judge knew all that. If the prosecutor hadn't said anything, the judge still knew it all. And basically was saying he disagreed with the prosecutor's
Well,
decision here.
I wouldn't agree that the judge still wouldn't be influenced by the rest of the record that was presented for sentencing besides the pre-sentence report. And the judge even said the pre-sentence report and the probation officer's recommendation is just based on these facts. And I have to review more. And so part of that was the representations by the government and the conclusions drawn.
Thank you. Mr. Katzoff, you were appointed by the court to represent the appellant in this case, and the court thanks you for your assistance. The case is submitted.
Case number 25-5219. True the Vote Inc. versus Internal Revenue Service et al. Bob Law Firm PC appellant. Mr. Bob for the appellant, Mr. Lockerbie for the appellant.
Good morning, Mr. Bob. You may proceed when you're ready.
Thank you, Your Honor. May it please the court. I'm James Bob Jr., attorney for the Bob Law Firm. This is a relatively, in my opinion, straightforward case regarding the validity of a attorney's lien under Indiana law. Bob Law Firm's lien is valid because, one, the client, True the Vote, and the former attorneys failed to even contest the validity of the lien, even though given numerous opportunities to do so, and in fact expressly conceded this. Second, the court below erroneously considered this issue, though it was never raised. Third, Indiana law is clear that there is a equitable lien in a fund received by the client through the efforts of the attorney. And finally, the record reveals that the funds here were secured by the efforts of the Bob Law Firm. So first, True the Vote and...
Can I ask a threshold question?
Of course.
If you're right, all right, that there was an error of law, and the case goes back to the district court, then what is your position?
On what, Your Honor? My position on?
You're seeking attorney's fees, right?
Yes.
You want to be paid,
Yes.
and that's why you want a lien.
Yes.
So what do you do with the lien? What happens?
Oh, I'm sorry, Your Honor. There's a fund that
Is there a fight over priority?
Yes.
All right.
And there
Is
is,
there a fight over the client agreement?
client's grievance.
The client's agreement.
Oh,
Agreement.
no, not that I know
You
of.
say the client has turned over any right the client
Yes.
has.
They have assigned those to us.
Funds that are what I'm calling the Equal Access to Justice Fund.
Yes, that is the fund.
All right.
And yes, priority is an issue to be resolved by the court
All
as,
right. So suppose the district court rules that the former attorney's lien has priority over yours.
Mhm.
Then what?
they would be fully paid whatever amount the court finds they are owed, which is,
Suppose hypothetically,
Hmm.
because I don't know the amount of that being. Suppose it's the whole 700,000.
it's over 600,000 they're claiming. The fund has almost 800,000. So there would be a residual, which we would be entitled to either because our lien is secondary or because of the assignment. So I don't think there's any contest of we would be entitled to the remainder.
I'm just trying to think of how this court's opinion can bring this matter to a close. And that's why I'm trying to understand what your position
Sure.
is, because I found the brief not helpful. All right? I
Well,
understand you think there's an error of law. All right? And I thought, then what happens? So you are saying, and I think you say this in your brief, that you agree the former attorney's lien comes first.
I do not agree that they come first.
That's what I thought. All right. So here's my hypothetical. There's $700,000 in the Equal Access to Justice Fund. The prior attorneys take 700,000. Then what?
If the fund is exhausted, then we receive nothing. The fund won't be exhausted based upon because these were the issues you're referring to were pending before the court for decision, i.e. the priority, who has priority, and how much the lien was to be valued at. Those were both pending. The judge had asked us to brief those questions specifically. He did not ask us to brief the validity of the lien. It was never briefed and in fact conceded repeatedly.
Well, they
that-
conceded it insofar as the Bopp Law Firm claimed 150,000 and change, but they did not ever concede that the lien allowed you to claim hourly rates under the truth vote agreement beyond that. So it's just not fair on the record, which I've read, to say that they conceded that the attorney lien would entitle you to the full amount of what you claim under your retainer.
I didn't say that. What I said was that there's two elements to what you're saying, and these were conflated throughout the litigation. One element is, did we have a valid lien? The second issue was, how much is that lien? How do you value it? And then, of course, the subsidiary question is who has priority, all right?
So they don't, as I understand it, and they can speak for themselves, the former attorneys don't, as you say, they don't dispute that there was a valid lien, but they understand there to be a valid lien for the amount that the Bopp Law Firm submitted for each of fees at the 150,000 odd. And so they're not disputing that. Even now, they're not disputing that. They're not claiming more than what they submitted that yielded the $638,500 of fees.
Yeah,
So there, I think the parties agree there was a valid lien at least up to BLF's claimed EJA amount.
Yeah, but those two are separate issues.
No, I understand.
Okay.
I understand. You did a very clear job of explaining that in the sense that one, is there a valid lien? And then two, what does that get you? And you say that secures the full amount of your retainer at your hourly rate, not at the $150 an hour rate. I understand.
That's correct.
that
We're arguing over the amount.
that's your position. But if the basis for the lien is that it results from that the attorney's effort secures the fund, your position, I take it, is that your effort secured the fund because you were the signatory on the EJA petition. Is that right?
It's a little more difficult than just signing your name, Your Honor, to get an award under the Equal Access to Justice Act.
So your position about whether the Bopp Law Firm's effort secured the fund? That's what I'm asking. What is that, your position on that?
Yeah, exactly. That is, it was the efforts of the Bopp Law Firm. It
But
started.
can you explain that? Yeah.
Of course. It starts with the consent decree. All the efforts by the former attorneys created no benefit to the client, no ruling by any court that provided them substantive relief. The only one they won was in the Court of Appeals on a mootness question. Was the case moot? And the DC Circuit said, no, it's not moot. And so it went back. When we got into the case, in other words, all their efforts were futile. It accomplished nothing. But when we got into,
You see, that's what I'm trying to understand about how you want us to look at this case. All right, because you are making that type of argument, which means we go back to square one. And that's what your brief said to me. Because you think you're entitled to more than 150,000,
Mhm.
even though that's the cap under the EAJA statute. So there'll be an argument about that.
yes,
There'll be an argument about priority. There'll be an argument about attorney's fees. All right. And what else is there going to be an argument about?
that's what I know about.
Because your argument, I thought, was not the response you just gave to Judge Pillard. But I thought you had agreed that that fund should be apportioned.
Oh, that was a compromise in mediation where we, and we mentioned that in a footnote, that would net about 400,000 to each party, and we offered that as a compromise in mediation. But what is being contested is whether we are entitled to the $505,000 we have demonstrated through our billing that were the hours we spent and then at the hourly rate agreed to, all right? And where they want that to be valued not based upon the agreement, but based upon how Equal Access to Justice Act funds are determined. That's apples and oranges big time, okay?
Oh, but that's back to square one. Okay, that's what I'm trying to get.
Yeah, that'll be an issue.
As to, there are some issues that the district court has decided. And when I read the district court's opinion, I read the district court to say, one, there was no, he certainly cited the Coons case and the two factors. All right. And he said, one, there was no agreement. And then he has some other language that's saying, nor, all right. So you read that as he's still on the agreement.
Yes,
But he says, you have to look to the client for anything in excess of what you're seeking.
well, if he's right,
No, but what I'm saying is, so then I read, well, you went to the client and the client turned over, assigned to you, any funds the client might be entitled to from the EAJA money. So when I read that, I thought, where is the case or controversy in this case? All right, EJA has a cap. They're offering you the cap. They're willing to take whatever is left. And so you get your money under the EJA cap and they get their money. But then when I read your brief, I understood, no, you really want to go back to square one on some of these issues. So the compromise that they're offering now is we're not even going to fight anymore about your entitlement to the 150. But you're saying you're owed much more.
yeah, because our lien is based upon the agreement. The Equal Access to Justice.
That's why the district court said, look to the client. And so you went to the client, you got the assignment.
But we get a lien under Indiana law for funds that have been secured by the client by our efforts. And to finish the answer to Judge Pillard's question, it began with getting a consent decree that we negotiated with the IRS that gave our client 100% of what our client wanted, plus the explicit permission, if you will, by the government that we can pursue attorney's fees. We then pursue attorney's fees under the Equal Access to Justice Act, and we are able to convince the court two very difficult things. First, that the IRS's position was not substantially justified. That gives us the statutory rate of $140 to be computed on how to compute the fund that is created, all right? And then we can convince the court, which is mind-bogglingly rare, that the government's position was in bad faith, which gives us market rates. And all of this is simply, how do you compute the funds, all right, that are owed as
Right.
reasonable attorney's fees
And then there's
under the ELJ?
And then there's a fund. Now, you're arguing now that your efforts secured the EAJA award. And you're
100%.
arguing that that is enough because, unlike what the district court held, you read Indiana law to require one or the other ground, not both.
I don't see.
So, is that right?
Yes, I don't see how you can read Coons when they say it's one or the other
And so
explicitly.
you don't need to, and you're not relying on the notion that you had any mutual agreement with True the Vote that your fees would be paid out of the EJA award.
That's correct.
You don't need to rely on that. That's not what you're relying on.
And that's not what we're relying upon. We're relying upon the agreement that establishes the attorney-client relationship and allowed us to do all this very beneficial work for
Now, why is
and
it-
the
yeah.
figure,
And-
and how much.
And you're not relying, you're not contesting that abuse of discretion is the standard for review.
Yes, I'm not contesting that.
To what extent is you make an argument that it's inherent authority? Is that different in your mind from equitable authority, or it's more or less the
It's
same?
broader. It's broader. But what is critical is what is the law? What is the law on equitable liens? The law in Indiana is without question that either you have an agreement with the client that you're going to be paid out of the fund, or there's no agreement and you have a fund that was created by your efforts.
So,
Either one, but
Right.
the lower court conflated those and said you needed an agreement, which is
So-
DC law, not Indiana.
so if there's a remand, the judge exercises his equitable discretion, is it your position that, it's clearly your position that it need not track the allocation under EJA? In other words, one way to look at the extent to which the award was a result of the attorney's effort is to say, well, that's very similar to the EJA inquiry itself, that some of the effort, no, I know you don't agree with that, but if the district court did think that, why would that be an abuse of discretion?
Because it's wrong as a matter of law, and those are de novo. I mean, there's a mixture here. All right. So some of these considerations, like what's the law on how equitable liens arise, that's a question of law under Indiana law. And the Indiana Supreme Court in the Coons case has clearly established that. And
I'm not following. If the question for the district court is whether the award was the result of the efforts, was secured by the efforts of an attorney, one or more attorneys. And let's say the district court thought, well, this award was secured by the effort of all of the attorneys involved.
Mhm.
You think that right there, that's an abuse of discretion?
No, I think that would be an exercise of the equitable powers of the court because, in applying the correct law. However, the correct law is that you don't have to be the exclusive generator of the fund. Okay. And of course, I think it's quite clear in the facts of this case that we were the exclusive generator of the fund. We won the case.
Well, let's say, I
And got
understand,
the-
I've heard you say that and I understand that that's your position, but I'm exploring your reaction to positions that aren't your ideal advocated positions. So
And they
let's
haven't
say a
done that
district
yet.
judge says that I think that there was, much of the house built and then maybe you put the roof on it. Nobody could live in it until you did that. But the house was also built by the contributions of others and exercised equitable discretion under the Indiana standard of attorney effort that secured the award.
Well,
What is your argument
Right.
that if the district court said, I'm just going to look to EJA to determine which portion of the award was secured by which of the lawyers, your reaction to that, if that comes up again or in arguing to the district court, is that would be an abuse of discretion.
That's what
Why?
I would argue that it's
Why?
abuse of discretion
Why?
because of the computations under the Equal Access to Justice Act is completely inapplicable because the lien is governed by the retainer agreement, not the Equal Access to Justice Act. And it specifies in the agreement how the hourly rates that are going to be applied to the work that we do.
Is the attorney agreement relevant? We're not talking about the mutual understanding that the retainer would be compensated out of the EJA award. We're
Right.
talking about whether the Bob Law Firm's efforts secured the award. You don't need an agreement for that, do you?
Well, you have to be an attorney
Right,
to the client.
right,
And under my ethical rules in Indiana, you got to have an agreement.
right. So you have an
Awful
agreement
fast,
and,
you know.
and let's say the agreement said, we'll represent you and we'll expect to be paid.
Yeah, and we
What
specify,
What about Indiana law under this prong that talks about whether the attorney's effort secures the award renders all of the lawyers whose efforts secured the award, like why would one lawyer get the hourly rate that they put in their contract and other lawyers not?
because once you check the box that you have a lien under, you secured the funds, and you don't have to be the exclusive one to secure the funds, that you secured the funds, then the valuing the lien is based on the retainer agreement. How many hours did you spend? What was the hourly rate? That's why. Under Equal Access to Justice Act, you have to show not substantially justified or bad faith here. And then you have a rate, $140 is the standard rate. You get market rates. And then in this case, the court cabined the bad faith to only a portion of what the lawyers did. And that's the reason mine was valued at
Right.
140.
Less, right.
Theirs were valued at market rates.
What's your Indiana law, I assume it would be Indiana law site for the notion that the value that you get from a lien that rests on the efforts of the attorney, the value of that lien is determined by the retainer. What's your best site for that?
I don't know a site for that. That's never been raised, so I haven't had the occasion to hunt for one.
So that's why the district court looked to what the intermediate Indiana courts had done. And basically they said, we have to look at these prongs together.
The intermediate,
And I know you disagree with that. And you read Coons, and there are two alternatives. But to respond to Judge Pillard's question, which I thought the district court was trying to figure out, well, what do I do? So he looks to the Intermediate Court of Appeals to figure out, and looks not only to the Indiana courts, but courts around the country, and says, this is how I have to look at this. All right. And I know you disagree with that, but trying to figure out what you're seeking other than the $505,000 that you say, as I understand it, you're entitled to. And I'm not questioning that under your agreement, but I'm just saying that's my understanding of what you think you're entitled to. Let's just make that a hypothetical. If you don't get that, that's because you think the district court has abused its discretion by virtue of an error of law.
Well, the error of law is conflating the two circumstances and requiring an agreement no matter what. And that's clearly not the law in Indiana. That would be de novo, I would think.
Well, you heard Judge Pillard's question. She's trying to get some understanding of what your position is. And my understanding that that's what the district court was trying to understand too.
Well,
And maybe he made an error of law, but I thought, what do you do? Basically, the way I read this was that the former attorneys had said, look, we've been struggling over this for 7 years. Let's end this. You get 150,000, we get our fees, right? You say no.
yeah,
You're the creator of the fund.
yeah.
It's only your efforts that created that fund. So we're back to square one, because that is not the way I read the district court's understanding of what happened in this case.
Well,
All right.
let me address.
So,
I'm
all we're
sorry.
trying to figure out is what can we say based on the issues that are before us that tries to clarify some of this. And maybe we can't. And this goes on for another 7 years. But that really is, and not questioning any representation you make as to what you're owed. But this could go on forever if everything has to go back to square one in terms of who actually, made an effort to get the government to enter this consent agreement and all of that long before you came into the case. That's all I'm getting at.
There's no dispute that we got this settlement, the consent decree. The former lawyers were gone, okay? Replaced by us. Several months later, we were able to negotiate and get 100% of what the client wanted. And then we were the ones that pursued the fund. But what I wanted to,
I mean, I don't know if that's undisputed. Imagine like I'm trying to open a can, twist it off, and I can't get it. And I hand it to somebody else, and they go pop, comes right off. I say, well, I loosened it for you. I mean,
they haven't argued that they were negotiating some consent decree. And in fact, I know that's not the case.
even if they weren't,
So I'm representing
even
this.
if that's not the case, isn't it conceivable that it was easier for you to get the consent decree because they had, loosened the jar?
There's no objective evidence that any jar was loosened by them. Everything that they tried failed except for reversing mootness. Significant, I agree, but that's it. No decisions, no concessions, no anything that benefited the client.
If they
We
did
were
no
at square
beneficial-
one when I
if they
got
did
in
no
the case.
beneficial work, then did the court err in including their lodestar calculation in the EGF fee award?
Their part of the calculation on their fees was at market rates.
I understand that.
We had-
Because
Not,
IRS was acting in bad faith.
yes. And the way those hours are valued is not at the statutory one.
I understand that. I've
I'm
read the briefs.
sorry.
So my question for you was, there was an award of fees, a calculation of fees. And the bulk of the fee that was awarded was based on hours contributed, and some of which were valued more highly, as you just said, because of IRS bad faith. But hours contributed by your firm, by the Foley firm, by the Center for Constitutional Jurisprudence, and by the Public Interest Law Foundation. Your position to us today is that nobody but your firm actually secured the award. And my question is, if they didn't contribute to the success of the litigation, is it error for the district court to have counted any of their work in the size of the pot?
It was not error
Why
to count
not?
their work.
Their
Well,
work
because
did
the way
contribute to.
because the way equal access to justice calculations go with respect to attorney's fees is in this case, it was from the very beginning. All right. Now, occasionally you have instances where a motion is filed, okay, and somebody says, well, that's not substantially justified, so,
Right,
or
you
in
took
bad
too much
faith.
time,
Then you
it
just
wasn't necessary.
then you get the award of pleadings that related to that.
Right.
This one
So-
was from the very beginning to the very end.
Things that contributed to the result in the case.
Well, it depends on what you think of as results. Okay, it is true that you calculate the fund based upon the attorney's fees, the attorney time, either times 140 or market to calculate the fund. That is true. That's what, but that does. But a lien by an attorney is calculated based if there is an agreement and it specifies hourly rates, it's based upon the time and hourly rates in the agreement. So these are just apples and oranges that don't have anything to do with each other. And so now, by the way, the Court of Appeals, Judge Rogers,
Yeah,
the Court of Appeals case is Hamilton.
yeah, it's one of them.
In Hamilton, the validity of the lien was conceded. It wasn't litigated. The Court of Appeals didn't say, oh, the law is all this. What is,
Questioning that.
okay, what they
I'm
said.
trying to say is that to answer the question that Judge Pillard put to you a couple of questions back, I thought the district court was trying to figure out, how do I answer this? And so he looked to these intermediate Court of Appeals decisions to try to figure out how the Indiana courts had looked at this. And indeed, how the Second Circuit, how the DC Court of Appeals and the Ninth Circuit, I mean, that's all I thought he was doing. I'm not arguing the facts of the intermediate appellate court cases with you.
Well, I'm not arguing the facts. I'm just arguing that what they said was we need give no time to a discussion of the validity or character of the claim of the lien because the appellant admitted that the appellee's attorneys has a lien on the judgment from which the appeal is taken.
I'm not.
The Hamilton was
Yes, sir.
completely meaningless
Yes.
to the question.
We're two trains passing in the night, okay? I'm not disputing what those cases are about. I'm trying to understand how the district court tried to answer the question that Judge Pillard raised. All right? That's all.
The court never tried to answer the question. Was there a fund received by the client that was a result of the efforts of the attorney? He never sought to decide that question. His only consideration was there an agreement? Well, that's wrong under Indiana law.
So do you dispute that? And I know you dispute the premise, but accept my premise for purposes of the question. If the former attorney's lien had priority,
Mhm.
I know you don't agree with that, but if it did,
Mhm.
assignment from True the Vote to you of its EAJA award would be subject to that lien.
True.
Okay. So just, I think you've satisfied me, you've answered my questions. On remand, just to recap, what do you think the district court still needs to decide?
Well, if we prevailed here, you would have a one sentence which says that Bob Law Firm had a valid lien and you'd remand for further consideration. Further consideration would involve things that were pending at the time the court issues its memorandum opinion,
How
which
could
were.
we decide that in light of some of the issues that Judge Pillard's question raised? All you have argued to us, as I understand it, is that there was an error of law because the district court only looked to one of the factors that the Kuhn case mentioned, and the district court needed to look to the second alternative, independent factor.
Mhm.
And so if we agreed with you, we would just send that back.
Yeah, and they would do that.
Decide. And the only thing I've been trying to figure out about this case is there any way to bring it to a close? And
No.
apparently the answer is no.
No. And I'm not happy about that. I mean, everything that was needed to finish the case was before the court. We had done supplemental briefing. And out of clear blue sky, something that the court has said in its order, former attorneys do not appear to challenge the validity of Bob Law Firm's charging lien, but instead insists that their charging lien has priority over the Bob Law Firm charging lien. That's on page 11. That's the district court's opinion about what happened here. And so out of clear blue sky, an issue that was never raised, actually conceded,
Can I ask?
never briefed, instead of deciding the priority,
Judge Pillar
the amount.
asked if this were remanded, what would the district court need to decide? What issues would be remaining? And you'd said we would issue a one sentence, remand, and then what would the district court, what would be left for the district court to do? What would your arguments to the district? You would be saying to the district court, we want some money because, and what comes after the because?
The priority of which lien, the former attorney's lien or our lien, which comes first? And then how much are we entitled to under that lien? Those are the two issues.
And the
then
former
the-
attorney's lien, at least chronologically, came first. Is that
Which,
at least chronologically came first?
The former attorney's lien in 2013.
yes, but there was a subsequent one that the court ruled was superseded and voided the first one.
So the district court would have to figure out which of the former attorney's two possible liens controls, and then figure out whether that one has priority to your lien. And then once that decision is made, would have to figure out the proper allocation of the money. Okay. It's totally separate, largely separate question. Coons is more than 100 years old. Their best case is more than 100 years old. We are not the Indiana Supreme Court. I know the district court asked both parties whether this should be certified, and no one wanted to. But have you had any occasion to reconsider that?
I don't think it's accurate to say we didn't want that to happen, because that'd have been fine with us. However, Indiana rules provide that what the question that you're asking the court to decide has to complete the litigation. Okay, all right, not be at some intermediate step in the litigation. And we're involved in an intermediate step right now, as you've just had me explain.
I think that might be right. That might be what Indiana's rules mean by dispositive.
Yes.
If we were to affirm based on the district court's understanding of Indiana law, that would complete this case.
If you win.
No, if he loses.
No, that's my point.
Yeah, no, you know what? That's I hadn't thought of that angle. And that's
You
maybe,
haven't persuaded Judge Rogers though.
that's
It
fine.
hasn't persuaded me.
But,
Going back to who actually established the fund.
but Judge Walker, that's really a good argument that I hadn't considered. Is it, there's one way of this being resolved that would complete the litigation on the lien, and that would be to affirm. So I'd be perfectly happy if you
I
to
think we should
certify.
certify to Indiana to find out whether this is certifiable.
I'd be very happy for you.
I don't think we should.
For that to happen, if you, and I have been ordered in litigation before to request that of state Supreme Courts, and familiar with the process, and I'd be all in for that.
Well, not every state has that same rule.
Sure.
It
Sure.
could be interim, but you're saying no, Indiana rule, and we'll read it.
Well, the way I interpreted dispositive, what I was thinking about
Yeah.
winning the appeal.
Yeah. So let's hear from the former attorneys.
Of course.
Thank you, Mr.
Thank you.
May it please the court. Michael J. Lockerbie with the law firm of Foley and Lardner, and also present until a minute ago at council table is Kaylin Phillips from the Public Interest Legal Foundation, to which I'll refer as PILF. Before addressing the issues I had planned to address, Judge Rogers raised an issue that I hadn't contemplated, but really is a threshold issue that I do believe needs to be addressed first, and that's case or controversy, and whether there is a case or controversy. And as I have thought about it the last 28 minutes or so, it occurred to me that there really isn't with respect to two issues. One is the issue whether the BOP law firm, BLF, has a lien under its agreement with the client through the vote. And it doesn't, because the BOP law firm sought two bites at the apple here. It filed suit in federal court in Indiana first to recover the same $505,000 that it now says is the subject of its, later said was the subject of its charging lien in the district court here in Washington. And I'm not going to do a dramatic reading of True the Vote's pleading, but we certainly quote it in our brief. And there's some pretty harsh words about the scope and nature of the representation. And rather than see that case through, the BOP law firm dismissed those claims with prejudice. And so it really is res judicata that there is no claim.
What's your best precedent for the proposition that a voluntary dismissal with prejudice has res judicata effect?
Standing here today, I don't have one, Your Honor. Was not planning to make that argument, but if it's a dismissal with prejudice, it almost seems self-evident, because once the claim has been dismissed with prejudice, it can't be reasserted either in that court or anywhere else. The other issue about which there's no case or controversy is that the former attorney's charging lien exists and it has priority. And that was a finding by the district court that BLF did not appeal. And so
The district court find that your lien had priority?
it did.
Where?
I thought it was sort of a conditional sentence. That priority remains to be decided. That's it. Based on the priority of your lien. I thought priority is still an open issue.
If I misspoke, I apologize. I can certainly look for that or see. I will look for that in a minute. I believe that to be the case, but see if I can find it now, actually.
Is it, in your view, in the district court's opinion, or was it previous in the proceedings?
In the hearing, I think. You know,
Let's see. Certainly, the finding at ECF number 245 was the former attorneys have a valid charging lien. I don't know that there's I'd have to go back to that. I don't know there's an express holding that has priority, although it arose under a prior agreement, and it also arose under the equal.
What did you think about certifying this question about Indiana law to the Indiana Supreme Court?
I don't understand what issue needs to be resolved by the Indiana Supreme Court, because whether the test is either or both, either that the Bopp law firm secured the award, or that it was required to, or that it was entitled to the funds under the fee agreement, it can't recover either way. Because
I thought that if it's either or, then they have a valid lien. That would then raise the question about the relationship between its lien and your lien. And I thought that you had agreed that in that situation that the Bopp law firm would get some money.
if
That's more than what they're getting now, which is no money.
which is nothing. Well, that's correct. But the source of that lien would,
I didn't think that just because he invalidated their lien, does that mean they get no money?
well, we're not arguing that. I think a case can be made that they don't get it directly from the court, but the result would be the same in that there's $150,000 excess. And so the $150,000 would be payable to True the Vote. And under the assignment agreement that the Bopp law firm apparently has with True the Vote would be required to pay that $150,000 over to the Bopp law firm. And we're not contesting that.
And if they didn't, that would be a new case.
Let's hope not.
Let's hope it wouldn't be a new case.
Well, a new piece of litigation, if that's what Your Honor
Right.
was referring to, but that ought to be, the assignment appears to be fairly simple and straightforward. And so that if True the Vote received $150,000, which it can receive without reversal.
You're pretty confident they're just going to write that check.
I can't speak to that, but certainly.
And I don't want to speculate whether they would or wouldn't, but my point is, if we just say affirmed, I forget the case number of this case, but I think whatever the case number for this district court case is, that is a closed, and for the purposes of the Bopp law firm, they have nothing left to do. They have nothing they can gain from that district court case, this district court case. And then if they don't get the check for $150,000, I guess they could sue in what would be a new case with a new case number.
It would be, and that's a simple collection case because
Their assignment from.
because of the assignment by True the Vote. But with respect to what happened in this court, or the lower court, the findings, of course, the district court found that of the $788,539.30, only $150,000 and some change was attributable to BLF. And the district court made those findings based on filings that the BLF itself submitted. And that's how the district court came up with these numbers, $348,979 to PILF and $264,686.57 to Foley. And
before I knew of the assignment, okay, in terms of the chronology of this case. I thought the judge was just applying the equal access to justice ceiling,
I'm sorry, you thought the judge was,
applying the cap in the Equal Access to Justice Act.
oh,
No, you're saying no.
well, no, the judge in calculating fees as part of the EAGA award did apply a cap,
And that,
but also applied the information about who did what when to come up with those numbers. And the record is clear that virtually all of the substantive work was done by the former attorneys dating back to 2013 through February 2017, when BLF entered its appearance. And we've laid out in our brief why that's the case. ECF number 1, factual development, preparing and filing the complaint, responding to the motion to dismiss. That's ECF number 65 and 72. Obtaining reversal in this court of the district court's dismissal of the government defendants, which was key. And that's a reported decision from 10 years ago, 2016. Responding to the government's summary judgment motion, number 119. A successful motion for discovery under Rule 56D, that's ECF
so
138.
you're telling me that the way I should read the record is that the district court, and this is all clear from the record, asked the parties to make submissions. All right, he asked for 3 things, and one of them was the billing records. So the parties submitted that. And you're saying that it was on the basis of that information that the judge said, well, Bob Law Firm is entitled to $150,000.
That's correct, Your Honor. And it was based on that. And while those submissions to the court were signed by the Bob Law Firm, and there's also an issue, and it's not briefed, of judicial estoppel, frankly. They won on that motion, and now they're seeking a do-over years after the fact. And the record showing that the former attorneys contributed quite a bit to the work that was the subject of the EAGA award is not only established in the declaration of Caitlin Phillips, this ECF number 180, 180-8 in paragraph 4. Even in this court, the Bob Law Firm's brief, and this is on page 5, talks about extended discussions, review, input, and work of the former attorneys that went into the fee award. So the bottom line is the district court did not err by not allowing BLF to abuse the equitable remedy of a charging lien to take fees that had been earned by others for work done by others. And again, this was the award under the EAGA. It had nothing to do with the fee agreement.
Moving forward on that argument, assuming that is a correct way to look at the record, then even if, as the Bob Law Firm argues, the district court erred as a matter of law by not going to the second ground under the Coons decision, it was harmless error because there's no prejudice in the sense that the district court made a finding of the amount to which the Bob Law Firm was entitled based on the filings that were presented to the district court.
That's correct, Your Honor. And if the Bob Law Firm wanted more, well, obviously it did and does, if it wanted more than the district court was willing to award, then it had a remedy. And that remedy was under its fee agreement, but I'm using the past tense had because it doesn't have that remedy anymore. It filed that claim and dismissed that claim with prejudice.
So the result of the with prejudice dismissal would be to be claim preclusion against any claim based on the retainer agreement or any claim for fees whatsoever?
Based on the retainer agreement.
And so to the extent that the Bob Law Firm's position before us is A, the district court was wrong, that you have to have both factors, one factor is enough. B, the factor we're relying on is that our efforts secured the award. And C, we're entitled to at least the full amount we would be entitled to under our retainer agreement. It's only that third part that would be precluded.
Correct.
And so in your view, they would still be entitled to argue that I guess there's two ways they would get to the same result. One, that if they have a lien that does or does not, I guess, have priority over yours, that to the extent that their efforts secured the award, they'd still be entitled to that on an equitable basis without the retainer.
Under the Equal Access to Justice Act. And that amount is $150,000.
Right.
And some change.
Or if they've settled their entire claim to fees, but you're not arguing that, but if they had it to settle their entire claim to fees, they nonetheless would get the residuum because nobody else is claiming it?
If they hadn't settled their claim, they could seek more than 150,000.
But they haven't.
But they've settled that claim.
But you started by saying there's no case or controversy. But now I hear you saying there's a theory under which they can still seek fees. It's just bereft of their effort to inject their retainer into the size of the claim that they want.
You put that.
Their effort to inject the retainer, but also it's an unnecessary step because they already have an agreement from the litigation in Indiana that says that any amount awarded under the Equal Access to Justice Act is theirs, and True the Vote has to pay it over to them. And so really what they're seeking to do is, although they appealed the district court's order on the charging lien, that doesn't really solve their problem, because even if they have a charging lien, they would still have to go back and have a do-over of the entire EAGA fee award. And if, let's say they had a valid charging lien, it couldn't have attached before they entered an appearance in February 2017. And so basically they would be seeking to go back before the date of that alleged lien and take hundreds of thousands of dollars for work done by the former attorneys.
Mm-hmm. And you're not doing what the Bob Law Firm is doing and saying, well, yeah, we were undercompensated, both because even the bad faith amount doesn't match our hourly rate, and even more so, the EJA standard amount of $150 falls far short of our hourly rate. You're not saying, and therefore, if our lien has priority, we want all of it. And you're not doing that because you were representing them pro bono on the understanding that if there was fee shifting, you would get paid.
Well, it was pro bono representation, but we submitted.
Right. That's what I'm saying. You would get paid.
But if there were to be a do-over, there were a lot of fees that Foley and PILF, I can't speak for CJC, submitted that were disallowed. And so if we really wanted to go back to square one and relitigate that, then, there certainly are issues that, we could have raised, would raise, but aren't raising.
I guess I'm not entirely following do over the numbers going into the EJA award. I mean, I was pressing Mr. Bopp on his notion that the award, his efforts secured the award because the EJA award itself suggests that multiple attorneys' efforts secured it. But when you're talking about, I know this was an exchange that you were having with Judge Rogers. I'm just not sure that I see anybody asking to resubmit the EJA application.
No, we're not seeking that, haven't sought that,
But why are you talking about it?
well, the reason I'm talking about it,
Hypothetical question.
Yeah, that the amounts, the EJA award itself suggests that the fund was secured by the efforts of many different lawyers.
it says that, but then it also apportions that
Yeah,
and it's based on, the work that the district court found, each law firm had performed.
right.
And then there's certain aspects of that work that the former attorneys were compensated for at a higher rate, not necessarily what their standard rate would be, but certainly of a higher rate. And there's work that went to securing that award for which the former attorneys received no compensation,
Right.
including coming up with these numbers and the justification
Right.
for the award in the first place. So
So there was billing judgment, and then the district court ultimately reviewed and snipped and adjusted. And
yes, and that happened to everybody.
Yeah.
It wasn't just the Bob Law
Yeah.
Firm.
No, that's typical. But so that we're all on the same page. But when you're suggesting that someone is suggesting going back and redoing that, and maybe it did flow from the question I asked, but do you take Mr. Bob to be suggesting that? Do you take that to be a sequelae of some line of argument that we're discussing?
Well, if the district, I think the point is that even if the Bob Law Firm has a valid charging lien or had a valid charging lien, how would that change the outcome? Because the Bob Law Firm's work, for one thing, was all done after the work of the former attorneys at issue. So clearly, the former attorney's charging lien would have priority. That's one point. And the other is that basically, if the case were remanded to the district court and the district court, were instructed to go back to the drawing board and recalculate what it previously awarded under EAGA, it seems to me that's starting from scratch. That is a do-over.
And in your view, if we were to hold that the district court had misapplied the Indiana lien law to require both prongs, and really only one is required, A, does there need to be a remand? And B, what does the district court need to hold on remand? Decide.
Well, would also say that it was the Bob Law Firm never argued the first prong, the prong that it secured the result here until this appeal. That's not an argument that was made in the district court. That's nowhere to be found in all the briefs and the hearing transcripts or anywhere else. So,
But it is fair to say that it was arguing that it was entitled to a lien under Indiana law.
he was,
I agree with your point about it didn't, go into details, but that was the general argument.
that was the argument.
Oh.
Yes.
And so the district court, in its opinion, lays out the two prongs. All right. And I was trying, this is an experienced district court judge. I thought the district court judge is clearly aware of the two prongs and that they're independent. I mean, he can read. And so why doesn't he deal with both of them? And I thought, well, he was trying to figure out what does he do if he decides that the fund was created by the Bob firm's efforts. And that's why I thought he was looking to these other cases, but I may be wrong about all of that. But in any event, the issues, he asked for the briefing on all these issues. So he had everything before him when he ruled. And I thought, then what happens if we say there's an error of law because he didn't make an express finding about the second alternative. And I thought, well, what happens? And that's why my first question, argument open to Mr. Bob, was what's next? If you win on that error of law argument.
And this, the second argument that you're talking about is that the Bob Law Firm secured the award.
Yep.
But how could the district court have erred by making a finding for which there was no submission in the first place? Yeah, there's no submission by the Bob Law Firm in the record that, you know, its efforts solely secured those funds. I understand, you know, there's been rhetoric today about how the Bob Law Firm turned things around and the client didn't agree, but in any event, you know, the issue that was briefed extensively and also argued this morning was that the Bob Law Firm shouldn't have been held to the EAGA hourly rate, and that it should get a higher rate under its fee agreement, a fee agreement that it raised a claim for and then dismissed the claim with prejudice.
So in answer to my question, whether we would have to remand, what's your answer?
I don't believe that the court has to remand or should remand.
I mean, I'm assuming that we disagree with the district court's reading that you need both factors. If we so held.
That it would be harmless error.
Which would be harmless error?
That the district court's finding that Indiana law requires both factors would be harmless
And
error.
that's because the Bob Law Firm has forfeited the argument that it secured the funds?
That, and also, and of course, the reversal and remand would also require a finding that the Bob Law Firm had a valid charging lien, or maybe would after remand. But even if the Bob Law Firm had a valid charging lien, its charging lien couldn't start before it entered an appearance. And it can't go back and try to simply take money away from the former attorneys on the theory that it should have gotten more than what the statute says it should get. I mean, that's really an issue for Congress. If litigants and their lawyers don't like the hourly rate, index it to inflation, or to match the market in DC, it would have to be raised 10 times for better or worse. But
I may be not recalling in sufficiently, but was this extensively briefed, this harmless error argument in this appeal?
No, I don't believe so. We simply pointed out that the Bob Law Firm hadn't raised the, we of course were seeking affirmance, but we simply pointed out that the Bob Law Firm hadn't argued in the district court that its efforts secured the award. But moreover, the record didn't support that.
And I think you might be right about all that, but without more briefing, I think I would probably have more confidence in the district court deciding that question before we decide it without any briefing, or with hardly any briefing.
I would say that the Bob Law Firm had an opportunity to brief that before. How many bites at the apple?
Even the forfeiture argument that you're making seems like it probably best resolved in the first instance by the district court.
Well, why didn't the Bob Law Firm make the argument before? The Bob Law Firm filed 2 motions to an original motion.
Why didn't they make the argument that they did not forfeit The argument, or
Well-
why did they not make the argument that you think was forfeited?
Why did they not make the argument that they're now hanging their hat on?
I mean, that is what, what you just said is perhaps a very persuasive forfeiture argument,
Oh,
but usually persuasive arguments get made in briefing before courts decide them.
well, the two motions that the Bob Law Firm filed were its opportunity to speak now or forever hold its peace. And now, years after the fact, it's come up with a different argument that it wishes it had been made before. So did the district court?
I hear all that.
Yeah.
And I'm not saying that I think you're wrong. I'll drop it after this comment. I'll let you respond to my comment, and then I'll get out of the way here. But everything you just said seems like something you should tell the district court in your effort to persuade them that the Bob Law Firm has forfeited a claim. And if you succeed, good. And if you don't succeed, good for them. But it seems like it would be a bit odd for us to just decide it now.
Well, except if the alleged error were harmless error, there'd be no reason to brief it. And, we couldn't respond to an argument that wasn't made. We weren't going to, respond to a motion for charging lien and say, well, their arguments are wrong, but there's another argument that they could have made.
You forfeited your forfeiture argument. I'm just saying you haven't briefed your forfeiture argument. So that forfeiture argument shouldn't be decided until you've briefed it, probably before the district.
Well, except they didn't raise the argument
Isn't
before.
also the point that the district court held a hearing on this whole matter.
Yes.
And previously they issued an order saying, I want the parties to submit 3 things. All right, then he held a hearing. And everybody had a chance to speak and say whatever they wanted to. And the district court said, anybody got anything else to say? And the district court says, okay, I'm going to take this under advisement. He didn't say those exact words, but I mean, he issued his order later, or his memorandum opinion later, after the hearing.
A lengthy memorandum opinion, and Your Honor's characterization of what the district court said is certainly faithful to the transcript. And my synopsis was speak now or forever hold your peace. But there was plenty of opportunity for the Bob Law Firm to make this argument factually and legally. And for whatever reason, it did not.
So you just referred a few times to harmless error, and I'm not sure exactly what you're referring to. What was the error that was harmless?
I was referring I believe the phrase was actually in Judge Rogers' question.
I was going to say, don't blame the attorney.
No,
myself. Why isn't this harmless?
No, but it's not a blame. I think it's a fair characterization. And as
The district court erred in thinking both strands of the lien law in Indiana were required. And if that's error, we haven't decided that obviously, but assuming that were error, it's harmless because
there was no evidence or argument presented to the district court that Indiana law required both prongs and that the Bob Law Firm satisfied both prongs.
Well, so we're clear.
Wait,
Sorry, I don't want to mislead Judge Pillard here. But you go on and then I'll clarify.
you said there was no argument or evidence that Indiana law required both, but then the district court so held. And the strand that the Bob Law Firm was relying on before, I think, was that they had an understanding with True the Vote that they would be paid out of the EJA award. No?
Well, they had
They had a retainer and then
they had an understanding with True the Vote that was reflected in the fee agreement.
That
And
they
that-
paid their hourly rate and they had a lien, they're saying.
Yes, and the source of the lien could only be one of two things. It could either be the fee agreement or whatever they contribute to the EHEA award. The fee agreement is gone as the source of the lien at this point. So it's simply, what they contributed to the fee award.
And your position, so one way of looking at it is harmless error, but the other way is forfeiture. That they have never argued that until this court, that their efforts secured the award.
Yes. And they made that argument after dismissing their claims in Indiana.
They made that argument to us.
Yes, after dismissing their claims in Indiana.
All right,
Okay,
thank you.
thank you.
Did Mr. Bob reserve any time for rebuttal? You have your 3 minutes.
Thank you. Just a couple of points. First, the council argued and derived all sorts of meaning from the dismissal of the lawsuit in Indiana between the Bob Law Firm and True the Vote. That dismissal was based upon a confidential settlement. And he's reading into that settlement all sorts of things that I can't talk about. All right. And the dismissal was part of the execution of the settlement as explained in the dismissal pleading. The only other thing we know is that True the Vote assigned all of their interest in this fund to us. Now, what do we derive from that? Is that a negative inference should be drawn from that? Well, of course not. They're giving up any right they have to any of that to us.
Do you have any case law on whether, I think the way one measures claim preclusion is by what was raised in the complaint, and that any of those claims that are resolved with prejudice are thereby precluded. So we don't need to know the terms of the settlement agreement. We know that the case was dismissed with prejudice, and we know what the case was about. And so anything that relates to that same case is done. We can't relitigate that. I think that's the argument, preclusion, and I think there's support for that. Do you have anything to the contrary that you want to draw our attention to?
Well,
Any case law that says a dismissal, voluntary dismissal with prejudice lacks claim preclusive effect?
well, if it's based upon a settlement, logically, it's the terms of the settlement that would govern that action of the court in granting the dismissal. But no, I don't have any cases because this is the first time this issue has ever arisen. And I think it's perfectly obvious from what I can talk about and what has happened is there's no negative inference to be drawn from the settlement and dismissal.
Well, it's not a negative inference. It's just that that's over and can't be relitigated. That's all.
It's not being relitigated.
Right. So great.
It is
Then we
being.
agree.
It's being collected as a result of a lien. That is different. And that's my argument based upon something I haven't researched.
I thought that for race judicata purposes, that it is often the case that a dismissal with prejudice is on the merits, but it will sometimes be the case that it's not on the merits. For example, if it was a statute of limitations reason in federal court, it might then be litigated in state court.
Mm-hmm. Of course, or a settlement where.
And you might be wrong about the race judicata. They may be entirely right about race judicata, but it again seems like something that has not been.
Though that's true, but here the critical element is the settlement, and the settlement's confidential.
All right, so
Second.
do you
Can I-
want to just wrap up?
Yes, I would want to wrap up by saying that as the court found in the opinion you are reviewing, former attorneys never, ever, ever contested the validity of the lien. Now, we did assert the lien and the justification for the lien in our notice of attorneys charging lien, which began all this, which is Joint Appendix 16 through 19, where we said, quote, that the Bob Law Firm has a substantial interest in any recovery, end of quote. Right? And then we, as a result of the briefing, our order by the court that resulted in this hearing that resulted in the opinion that we are being reviewed, in our supplemental brief, we said, Bob Law Firm seeks to have the fees and costs due them for services in the suit secured out of the judgment or recovery in the suit. So we absolutely argued that an equitable lien in the fund, we were arguing an equitable lien in the fund in both of those instances. Why didn't we go farther? It was never contested.
All right,
Thank you.
thank you.
This honorable, we have that here until Wednesday, whichever you on Thursday.